At 11:32 on the evening of August 7th, 2026, Catherine, Princess of Wales, was still awake in the private wing of Balmoral Castle when her personal solicitor called from London with a message that contained exactly 2 sentences. The first sentence identified a legal filing that had appeared that afternoon in the Edinburgh Court of Session, submitted by a commercial trust administration firm, acting on behalf of an unnamed beneficiary. The second sentence stated that the filing, if not resolved within 11 days, would trigger a mandatory judicial review of the entire Windsor grandchildren's settlement, a financial structure that Queen Elizabeth II had established in 2011, and that held, in protected trust, the private inheritance designated for every grandchild of the late sovereign. Catherine listened to both sentences. She sat for approximately 4 minutes in the small sitting room adjacent to her bedroom while the castle slept around her and the Scottish darkness pressed against the windows. Then she stood, crossed the corridor to the room where William was already asleep, and woke him with a single sentence that he would later describe to his private secretary as the only time in their marriage that she had entered a room carrying a problem that could not wait for morning. The problem was this. If the Edinburgh filing was not withdrawn or resolved by September 7th, a court would examine the internal structure of a trust that held the private inheritance of 7 children, including her own, and the mechanism Queen Elizabeth had designed to protect those children's financial futures from institutional interference would be exposed to judicial scrutiny for the first time. And the specific reason the filing existed, the specific administrative failure that had created the legal vulnerability, was that one grandchild's portion of the settlement had never been formally released to his trustees. That grandchild was Prince Harry, and the person responsible for the release was King Charles. By the end of this video, you will understand what the Windsor grandchildren's settlement actually contains, why Queen Elizabeth structured it the way she did, why Charles delayed Harry's portion for 4 years, and how Catherine's intervention the following morning did not simply resolve a legal crisis, but fundamentally altered Harry's relationship to the institution's financial architecture in a way he had not requested and did not initially understand. Before we trace what happened in the meeting that followed, make sure you are subscribed. There are structural details in this story that no financial correspondent has identified, and implications that reach far beyond a single trust document. The Windsor grandchildren's settlement was not a public instrument. It was not referenced in any parliamentary document, any Crown Estate filing, or any royal household annual report. It existed in the private legal architecture of the sovereign's personal estate, established in 2011 through a trust deed executed by Queen Elizabeth II with the counsel of 3 senior chancery lawyers whose names appear nowhere in the public record. The settlement was funded entirely from the Queen's private wealth, separate from the sovereign grant, separate from the Duchy of Lancaster, separate from the asset subject to parliamentary oversight or public accounting. Its purse to provide each grandchild of the sovereign with a protected financial foundation that could not be altered, reduced, restructured, or withheld by any future monarch, any future government, or any future institutional decision. The settlement was irrevocable. Its terms were fixed at the moment of execution, and its distribution mechanism was designed to operate automatically upon each grandchild reaching the age of 25, with no discretionary authority granted to any intervening party. 7 grandchildren were named in the settlement: the children of the Prince of Wales, the children of the Duke of York, the children of the Earl of Wessex, and the children of the Duke of Sussex, born and unborn at the time of execution, with provisions for subsequent additions. Each grandchild's portion was equal. The settlement did not distinguish between children of working royals and children of non-working royals. It did not distinguish between children residing in the United Kingdom and children residing abroad. It didn't distinguish between children whose parents maintained active institutional roles and children whose parents had departed them. The Queen was explicit about this equality in the trust deed's preamble, a passage that her lawyers recorded in her own words during the drafting sessions. She stated that the settlement existed to protect children from the consequences of their parents' choices, and that no child's portion should be contingent on any parent's relationship to the institution. The money belonged to the children. Not to their parents, not to the Crown, not to any administrative body, to the children. And the mechanism of delivery was designed to be automatic precisely so that no individual, regardless of title or authority, could exercise discretion over the timing or conditions of release. But automatic mechanisms require administrative execution. The trust deed specified that upon each grandchild's 25th birthday, the sovereign's private secretary was obligated to issue a formal release instruction to the trust's administering solicitors, authorizing the transfer of that grandchild's portion to their designated personal trustees. This was not a discretionary act. It was a ministerial function, equivalent to signing a form that confirmed a date had arrived. For the grandchildren who reached 25 during Queen Elizabeth's lifetime, the release instructions were issued within days of the birthday, processed quietly, and completed without public record. For the grandchildren who had not yet reached 25 at the time of the Queen's death in September 2022, the obligation transferred to the succeeding sovereign. King Charles inherited the duty, and for 4 years, regarding one specific grandchild's portion, he did not execute it. Prince Harry turned 40 in September 2024. The settlement's provisions for grandchildren who reached 25 before the trust's execution included a modified distribution schedule, but the core release mechanism remained identical. A formal instruction from the sovereign's office to the administering solicitors, a transfer to the designated personal trustees, a completion notice filed in the private legal archive. Harry's portion should have been released in 2011 when the trust was executed, as he was already 27 at that time. But the trust deed contained a specific provision for grandchildren who were already adults at the time of execution. Their portions were to be held in continuing trust until the sovereign issued a personal release instruction, separate from the automatic 25th birthday mechanism. This provision existed because the Queen understood that adult grandchildren might require the funds at different times, depending on their circumstances, and she wished to retain the ability to time the release to the moment of greatest utility. It was a kindness built into the structure, a flexibility, and it was the flexibility that Charles exploited, or rather that Charles allowed to become a weapon through inaction. For 4 years, the release instruction for Harry's portion sat unsigned, not rejected, not formally withheld, simply unsigned. The document existed in the private secretary's office, prepared and awaiting the sovereign's signature, as it had been prepared and awaiting signature since 2011. 15 years. Through the final decade of Elizabeth's reign, the document had remained in the same file, untouched, because the Queen had determined that Harry's portion should be released at a moment she had not yet identified. When she died, the decision transferred to Charles. And Charles, navigating the first years of his reign with a focus on structural consolidation and institutional reduction, allowed the document to remain in the file, not out of malice, not out of a desire to punish his son, but because signing it required engaging with the question of Harry's relationship to the institution, and engaging with that question required confronting a set of emotional and institutional complexities that Charles, in the early years of his reign, was not equipped to process alongside everything else demanding his attention. The document sat. The portion remained in trust. And the legal vulnerability grew. The vulnerability was this. The Windsor grandchildren's settlement was structured as a single unified trust with 7 beneficiary portions. It was not 7 separate trusts. It was one trust with 7 allocations. And under Scottish trust law, where the settlement was registered for tax and administrative purposes, a unified trust required that all beneficiary portions be in active administrative status. If one portion remained in indefinite holding while the others were released or progressing toward release, the trust's unified status became legally contestable. Any beneficiary, or any party acting on behalf of any beneficiary, could file a petition arguing that the trust was being administered unequally, that one beneficiary was being treated differently from the others, and that the court should intervene to ensure uniform administration. This was not a theoretical risk. It was a structural reality that the trust's administering solicitors had flagged in written memos to the private secretary's office in 2023, 2024, and 2025. Each memo recommended immediate execution of the outstanding release instruction to eliminate the vulnerability. Each memo was acknowledged. None was acted upon. Then, on the afternoon of August 7, 2026, the theoretical became actual. A commercial trust administration firm in Edinburgh, acting on instructions from a beneficiary's representative whose identity was sealed in the filing, submitted a petition to the Court of Session requesting judicial review of the Windsor grandchildren's settlement's administrative status. The petition did not name Harry. It did not name the royal family. It referenced the trust by its registration number and alleged that one beneficiary's portion had been held in indefinite suspension without administrative justification, creating inequality of treatment that violated the trustee's own terms. The petition requested that the court either compel immediate release of the outstanding portion or, alternatively, restructure the trust into 7 independent instruments, each administered separately. The second option was the one that terrified Catherine's solicitor, because restructuring the trust into 7 separate instruments would dissolve the unified protective architecture that Queen Elizabeth had designed. It would expose each child's portion to individual legal challenge rather than sheltering them within a single structure whose terms were fixed and irrevocable. It would transform a protected inheritance into 7 vulnerable ones. And it would do so because one signature had not been placed on one document for 4 years. Catherine understood all of this within the 4 minutes she sat in the dark sitting room at Balmoral. Her solicitor had explained the mechanics. She did not need them explained twice. She understood that the petition was not an attack on Harry. It was an attack on the structure that protected all 7 children, triggered by the administrative failure to process Harry's portion. She understood that if the court intervened, the consequences would not fall on Harry alone. They would fall on George, on Charlotte, on Louis, on James, on Louise, on Beatrice's children when they were added. On every child the settlement was designed to protect, and she understood that the only person who could resolve the crisis before the September 7th deadline was the person who had created it, the king. The signature, the document in the file, 15 years old, waiting. She woke William. She explained the situation in the compressed language of someone who has already organized the facts and needs only to transmit them. William listened. He asked 2 questions. The first was whether the petition could be withdrawn without the release being executed. The answer was no. The petition could only be withdrawn if the underlying grievance was resolved, and the grievance was the unsigned release instruction. Was whether Catherine was certain that the meeting needed to happen before morning. She said yes. Because the petition's filing was now a matter of court record, and every hour it remained unresolved increased the probability that a legal journalist or court correspondent would identify the trust registration number and trace it to the Windsor family. The window for quiet resolution was measured in days, not weeks. And the person who needed to sign the document was asleep in the east wing of the same castle, 3 corridors away. William sat up. He said one word, "Go," and Catherine walked out of the room and did not return until the matter was resolved. She did not go to the king's bedroom. She did not send a note requesting a morning audience. She went to the private secretary's office, which maintained a night duty station during the Balmoral residency, and she asked the duty officer to wake the king's private secretary with a message that the Princess of Wales required a 5-minute conversation before the household rose. The private secretary appeared within 12 minutes, dressed but visibly disoriented. Catherine explained the situation. She did not ask for advice. She did not ask for assessment. She said, "I need to see His Majesty within the hour. I need the release document brought to the meeting, and I need the Trust's administering solicitor on the phone from Edinburgh by the time the meeting concludes." The private secretary, who understood immediately what the petition meant and what the deadline required, made 3 phone calls. The king was awake by 12:15. The meeting was set for 1. The solicitor in Edinburgh was contacted and instructed to remain available, and Catherine sat in the small anteroom outside the king's private study for 45 minutes, holding the folder her solicitor had transmitted electronically, waiting for the door to open. The meeting lasted 37 minutes. It took place in the king's private study at Balmoral, a room that carries the specific weight of generations of sovereign decision-making, where the walls hold the accumulated silence of conversations that shaped the institution across centuries. Charles was seated at his desk. Catherine sat across from him. The private secretary stood at the periphery with the file. The release document was on the desk. It had been retrieved from the archive cabinet in the private secretary's office, where it had rested since 2011. 15 years. The paper had yellowed slightly at the edges. The trust's seal was printed at the header. The language was formal, precise, and brief. It authorized the administering solicitors to release the designated portion of the Windsor grandchildren's settlement, the personal trustees of Prince Henry Charles Albert David, Duke of Sussex. It required 1 signature. It had required 1 signature for 15 years. Catherine did not begin with the legal crisis. She did not begin with the petition, or the deadline, or the consequences of judicial intervention. She began with a question that she had formulated in the 45 minutes she sat in the anteroom, and that she understood would accomplish something no legal argument could. She said, "Your Majesty, may I ask what you believe this document represents?" Charles looked at the paper on his desk. He did not answer immediately. She continued, "I ask because I have read the trust deed. I have read the preamble in your mother's words, and I believe this document represents her final act of provision for Harry. Not a reward, not a reconciliation gesture, not an institutional acknowledgement, a mother's provision for her grandchild, signed into law 15 years ago, waiting only for the person she trusted to complete the delivery. And I need to understand what has prevented that completion, because in 11 days a court in Edinburgh will examine why it was not completed, and the answer the institution gives will determine whether 7 children keep the protection your mother built for them or lose it to judicial restructuring. The private secretary's record of the meeting notes that Charles was silent for approximately 30 seconds after Catherine finished speaking. Then he said something that was not recorded in formal language, but that the private secretary transcribed as closely as memory permitted. He said, "I did not withhold it. I simply did not sign it. There is a difference." And Catherine said, "Your Majesty, I understand the difference in intention, but the court will not understand the difference. The court will see a beneficiary whose portion was held while every other beneficiary's portion was processed. The court will see 4 years of administrative inaction following the sovereign's succession. The court will see inequality of treatment, and the court will restructure the trust. And when it does, the protection your mother built for George and Charlotte and Louis will be dissolved along with the protection she built for Archie and Lilibet. And I will not allow that to happen because a document sat in a cabinet for 4 years. Not because of what it means for Harry, because of what it means for my children. And I believe you will not allow it either." Charles signed the document at 1:24 in the morning. He signed it at the desk in his private study at Balmoral Castle, under the lamplight that cast the room in the warm amber tone that the castle's electrical system has carried since the 1950s. He signed it without additional comment. He signed it without conditions. He signed it without requesting that Harry be notified before the release was executed. He signed it because Catherine had made the consequences of inaction specific and immediate, and because she had framed the signature not as a gesture toward Harry, but as a protection for every child named in the settlement, including his own grandchildren. The private secretary countersigned. The administering solicitor in Edinburgh was contacted by telephone at 1:31 and instructed to process the release immediately upon receipt of the executed document, which was transmitted by secure electronic transfer at 1:38. The Edinburgh petition would be withdrawn within 72 hours once the court was notified that the underlying grievance had been resolved. The trust's unified status was preserved. The protective architecture remained intact. And Harry's portion, held for 15 years in a trust his grandmother had built for him, was released to his designated personal trustees before the sun rose over the Balmoral estate. Harry was notified on the morning of August 29th. Not by the palace, not by the king. By his personal trustees, a firm of London solicitors who had been designated in the 2011 trust deed and who had held the designation for 15 years without ever receiving the release instruction that would activate their authority. A formal letter confirming that the Windsor grandchildren's settlement portion, designated for Prince Henry Charles Albert David, had been released to their administration effective immediately. The letter included the settlement's reference number, the portion's valuation as of the release date, and a summary of the trust's ongoing protective provisions. Harry's response, communicated through his private office to the trustees within 24 hours, was a request for clarification, not about the amount, not about the terms, about the timing. Why now? Why after 4 years of silence? Why after 15 years of holding? The trustees could not answer that question. They had received the instruction, they had executed it. The reasons for the delay were not within their knowledge or their remit, but Harry understood, even without explanation, that something had shifted. And what had shifted was not his father's feelings. It was the institution's operational reality. This is where the story becomes genuinely complex, because the release of Harry's portion did not simply transfer funds. It activated a structural relationship between Harry and the institution's financial architecture that his departure in 2020 had been designed to sever. The Windsor grandchildren's settlement carried ongoing administrative requirements. Beneficiaries whose portions were in active trust status were required to maintain a registered address with the administering solicitors, to confirm annually that their designated trustees remained appointed, and to acknowledge receipt of the settlement's annual governance report. These requirements were not intrusive. They were not surveillance. They were the basic administrative maintenance that any trust structure required. But for Harry, they represented a formal connection to the institution's legal infrastructure that he had not maintained since his departure. The release did not give him money. It gave him a structural position, a documented, ongoing, institutionally recognized position within the framework his grandmother had built. and that position could not be declined without formally renouncing the settlement, an action that would generate public documentation and legal visibility far greater than the administrative connection itself required. Catherine understood this consequence. She had understood it before she walked into the king's study at 1 o'clock in the morning. She understood that releasing Harry's portion was not merely resolving a legal vulnerability. It was re-establishing a structural connection between Harry and the institution that his departure had severed. And she understood that this re-establishment served not Harry's interests alone, but the institution's broader stability, because a family whose financial architecture was unified was harder to fracture publicly than a family whose financial architecture contained gaps and disconnections that external parties could exploit.
She did not frame this argument to the king. She did not need to. She framed the argument in terms of her children's protection, and that was sufficient. But the structural consequence was deliberate. She knew what the release would create. She intended it to create. And she accepted that Harry might experience the reconnection as an imposition rather than a provision, because she understood that the alternative, judicial restructuring of the entire settlement, would damage every child in the family, including her own. But there is a final element to this story that must be addressed, because it is the element that reveals the full scope of Catherine's calculation. The Edinburgh petition was filed by a commercial trust administration firm acting on behalf of an unnamed beneficiary's representative. The petition did not identify the beneficiary. Court filings sealed the name, but the trust's administering solicitors, upon processing the release instruction, noted in their internal record that the petition had been filed by a firm that had been contacted by Harry's previous legal representatives in 2024 during a routine inquiry about the settlement status. The inquiry had been withdrawn at the time. No action had been taken, but the firm had retained the settlement's reference number and the basic structural detail. When Harry's previous legal team dissolved their relationship with his household in early 2026, as part of his broader advisory restructuring, the firm retained the file. And when the annual trust governance report was distributed in June 2026, listing all beneficiaries and their administrative status, the firm identified that one beneficiary's portion remained in indefinite holding. They filed the petition not at Harry's instruction. They filed it because their professional obligation to the trust's integrity required them to flag administrative inequality when they identified it.
Harry did not trigger the crisis.
But his departure from the institution's active structure had created the conditions in which the crisis became possible. Catherine knew this. Her solicitor had traced the petition's origin within hours of receiving the initial call. She knew that Harry had not filed the petition. She knew that the filing was the product of administrative drift colliding with professional obligation. And she knew that presenting this information to the king would have complicated the meeting, introduced questions of blame, and potentially shifted the conversation from resolution to recrimination. She chose not to present it. She chose to frame the crisis as structural rather than personal, as administrative rather than intentional. She chose to make the solution simple: one signature, one document, one act of completion that resolved the legal vulnerability without assigning fault. And in making that choice, she accomplished something that no previous intervention in Harry's institutional relationship had managed. She resolved a crisis affecting him without requiring him to participate in the resolution. He did not ask. He did not negotiate. He did not engage. The institution completed its obligation to him because a woman in a castle at 1 o'clock in the morning understood that the obligation existed and refused to let it remain unfulfilled. If you have watched this far, you now understand not just what happened at Balmoral on the night of August 7th, but why it could only have been Catherine who acted, why the meeting took place at 1 in the morning rather than at 10 the following day, and why the resolution took the specific form it took. You understand that the emergency was not dramatic. It was a signature, a document 15 years old, a trust provision that Queen Elizabeth had written in language that left no room for discretion. And you understand that the change for Harry was not a gift. It was a completion. The institution finished what it owed him because his grandmother's framework demanded it, and because a woman who read trust documents in the dark understood that finishing it protected everyone. Not just Harry. Everyone. Every child named in the settlement. Every child not yet born who would one day be added to it. Every child whose financial future depended on a structure that could only survive if every portion was treated equally. The meeting lasted 37 minutes. The signature took 4 seconds, and 15 years of administrative silence ended in the amber lamplight of a castle study, while the Scottish darkness held everything else in stillness. Subscribe, because the next chapter examines how the Windsor grandchildren's settlement's preserved structure is already shaping the financial architecture of the next generation's transition in ways that will define the monarchy's economic foundations for the next 50 years. The document is signed, the portion is released, the trust holds, and somewhere in London, a firm of solicitors who have held a designation for 15 years are finally executing the instructions their client wrote in, trusting that one day the signature would arrive. It arrived 15 years late, and exactly when it was needed.